Well, several preliminaries. Thank you, Don. I've been looking forward to this. And getting ready for these sessions forced me to do something that I had not done. Even though I had been through all of these regulations and all of the statutes that apply to the department at one time or another and in bits and pieces, I had never taken our parks-related regulations and gone through them just right from the beginning to the end. My advice to you is that there are better ways to spend a couple of evenings than reading these regulations. That is not to be interpreted as in any way critical of the regulations. I got a better appreciation for them after seeing them all at one time in one body. As we go through them, I think we can find areas that perhaps deserve some change, but they are a fine body of regulations. The handout is an outline that I prepared mostly for my own benefit, but I decided to duplicate it and distribute it to you, mainly because it was so long. I thought when I started there'd be about 5 pages. Ended up about 3 times that much. Now, we make a deal. Either we go through this whole thing word by word, or you take your copy home and read it at your own leisure and give Boswell your Boy Scout honor that you've studied the regulations. If what I propose to do is use this outline as a basis for our session this afternoon, not necessarily look at everything. As we go through it, you'll see that for the most part it is a very skimpy outline. It is no substitute for the regulations themselves. What I've done is have, after some introductory material, I have summarized most of the regulations and have made some cross-references to the statutes and a few, but very few comments of my own about interpretation and problems involving the statutes. Let me ask a question or two before we get into this. Do most of you or all of you have a copy of the park regulations themselves with you for these sessions, or have you? Yeah. Where do we stand on that? Who's got a copy of the whole regulations themselves, either in the little green booklet that's been floating around or in a Xerox copy of the regs? Do you all have that? Yeah. Don't have. Okay, fine. No. All right. I guess. Yeah. Well, I know there's not enough to go around, and that was one reason. Another reason I wanted to do them. The outline. In any event, where I have just listed the subject of a regulation, obviously, if a question comes up, you need to go to the regulation itself. It may be that this this outline would do you some good after this training session, and frankly, I don't know, and I'd appreciate any feedback. I know that if I go over it again, I can improve on what I've done, and if it would be of any help to you in your duties to have something like this, or in a shorter form, as a reference to regulations, well, I'll try to polish this up and revise it a little bit and get it distributed. if you're familiar enough with the regulations themselves that that you can go right to them and can write, scribble notes on your copy and stuff like that, you may be just as well off sticking with the regulations. Needless to say, I don't know, well, I don't know several things. I don't know the answers. In a lot of cases, I don't even know the questions. I don't know what your particular problems may be. I've got some thoughts on things that need emphasis, but as we go through this, if there are areas that that you want to talk about, bring out problems you've had or ask questions, let's do it. And I may be able to help you, and I may not. If I can't help you today, I'll try to help you on it later. Just reading over these the last few days made me realize that some questions have come up on the interpretation of the regulations that I could not even answer, or at least did not get a chance to research. And I've just got questions about some of these things that I'm really not ready to express an opinion on. What I did in this outline, beginning on the first page, I've said background. And I thought it would help to just to cite to you the main Tennessee Code references, the statutes that create and provide for the administration of the department and of parks, archaeology, trails, scenic rivers, and natural areas. I don't know how much you've got a picture of what regulations are. Now, I use the phrase rules and regulations really interchangeably. The statute uses them interchangeably, and the official compilation of state rules says state rules and regulations. It's all the same thing. In governing the state or any other body, we start with our Constitution, and then the legislature enacts statutes with the concurrence usually of the governor. Courts interpret those laws and other laws, and then typically in the administration of any government, the statutes authorize somebody to adopt regulations. So in the hierarchy, you look at the Constitution at the top and the acts of the legislature below it, and regulations of a department are down below it. Regulations implement statutes. They don't take the place of statutes. A regulation might take the place of a statute, but the authority for the regulation is the authority contained in a statute to tell somebody to issue a regulation. For the Department of Conservation, the statutes authorize Commissioner Howell to adopt regulations. The Administrative Procedures Act, particularly as amended by the legislature in 1982, has a very particular and detailed and somewhat cumbersome procedure for dealing with regulations and their enforcement. A commissioner cannot simply sign a memo and circulate it and have it thereby be a regulation in the sense that we're referring to regulations here. The Administrative Procedures Act requires that public notice be given, that the text of a proposed regulation be made available for public comment if the public wants to comment. Public hearings are not mandatory but are often held. The department then promulgates a regulation after these procedures. It then goes to the Attorney General for a very thorough legal analysis to determine whether it's legal. And if the Attorney General approves it, then the Secretary of State publishes it. And with the certification of the Secretary of State, it is an official rule and regulation of that department. Why bother with mentioning all that? Is to indicate to you where the regulations come from and where they stand. For your and our purposes, a regulation can be treated as having the effect of a law. It is binding within the scope of what it says, provided that it was promulgated lawfully in accordance with the Administrative Procedures Act, and provided that it is consistent with the statutes. If the statute says Director of Parks may not do such and such, the Commissioner of Conservation cannot promulgate a binding regulation which says the Director of Parks can do such and such. The statute is higher than the regulation. But as long as the regulations are consistent with the statute, we treat them as they are of binding effect. And they are effective statewide to the extent that they are of by their terms of statewide application. So we use regulations a great deal. Generally speaking, a statute is in somewhat general terms. The regulation goes into more detail, and very often the regulation then further delegates authority and discretion, in our case, to the Director of Parks or to the superintendent of a given park or to someone else to make further detailed and particular rules. But those rules that may be posted, of course, don't stand on as high a footing as a regulation that's been promulgated in accordance with the statute. But they are, nevertheless, enforceable. If the statute has authorized the Commissioner to issue a regulation, the Commissioner has issued a given regulation, and the regulation says, for example, that the superintendent of a park can post the hours when people are permitted to swim in the pools or to ride motorcycles on the paths. But that to do it, he's got to post it in a prominent place and so on. Then you're entitled to enforce those detailed rules as to when people can swim or ride motorcycles or something else. But everything has got to rest on some authority. All of these rules need to be read with a requirement that they be reasonable in nature, not arbitrary, capricious, unreasonable. If we can apply words like arbitrary, capricious, and unreasonable to them, then we're just looking for trouble if they're challenged. Those are the words that we use to say that something violates due process of law. And when a regulation gives, say, the superintendent some discretion, that discretion needs to be exercised reasonably, not arbitrarily and capriciously, not unequally. Got to be applied equally to people who are similarly situated. And so the same applies where you are authorized to do something. You obviously need, to the best of your ability, apply the regulations and the restrictions equally and evenly in similar situations. I cited toward the bottom of this page some provisions of the Administrative Procedures Act. They include, as this statute says, statements of general applicability. We don't use regulations for little funky temporary or internal decisions. Rules within the scope of the statute, as I quoted at the bottom of that page, do not include statements concerning only the internal management of state government and not affecting private rights, privileges, or procedures available to the public. Primarily, the regulations that are enacted or promulgated by the Commissioner, the same is true, of course, throughout every department in the state, are not for internal management, not to tell, one person how to deal with somebody in the chain of command, not to designate hours and shifts and things like that, but to set out the requirements and the rules for administering the department in its dealings with the public. That's what the regulations are primarily for. Quoted a few things on the second page, which you guys know. If you haven't seen it in the statute, you nevertheless know it better than I do. But in thinking about how you enforce regulations and what's permitted and what's not permitted, I think it's good to keep in the back of our minds what the parks are all about, why they're here, what the state policy is that has been carried out by the creation of parks and natural areas and scenic rivers and scenic trails. And I quote from the regulation which our department adopted some 10 years ago. Tennessee state parks belong to the people of the state and are for the recreational use of the public. All visitors are welcome. The rules are, and I excerpted it, to prevent abuse and misuse of the privileges and the facilities that are provided. Just obviously we don't want to forget that. The park's not here just for your benefit and my benefit. The parks belong to the people. Visitors are welcome. And when we think in terms of restrictions, and that's what most of our regulations are restrictions on conduct, we need to remember the purpose and the function of the parks. And remember this, that generally speaking, people can do anything they want to do unless there's a law against it. Now, there are laws against an awful lot of things in this world, but you as law enforcement officers don't go around and just arbitrarily tell somebody you can't do something because you don't like it. People can do what they want to until it is contrary to a given law, which includes a regulation. And so our regulations are restrictions on the ability of people to do as they please when they come in the parks. And we need to find our authority when we tell a person he or she can't do something. We need to find our authority in the regulations or the statutes that they implement. What is a park? Parks, according to the code, are areas which, by reason of having natural and historic features, scenic beauty, or location, possess recreational values and are reserved and administered by the state for the recreational and cultural use and enjoyment of the people. Just another statement emphasizing the parks are for the recreational, cultural use for the benefit of the public. Parks are to be preserved in a natural condition consistent with use and safety. Improvements are not to lessen the inherent recreational values. And the parks are to be administered through the Division of Parks in the Department of Conservation. If you get into a situation where you are enforcing a regulation, citing somebody for a violation, we need to remember that if challenged, we go up through the chain of authority for your authority to cite somebody and to enforce a regulation. And once we get the regulation, the source, the authority for the regulation is the statute that authorizes the commissioner to promulgate it. And I'll comment in a minute on what I see is to be done when there may be a challenge raised to whether something is a violation of a regulation. On the third page on the Roman II, I've headed violations of park regulations and state laws, and I begin with an excerpt from the Tennessee Code as to your authority. Has everybody read that? You pretty well know it by heart. I think there's still there can still be questions as to what this code section 11-3-107 really means. When it says when properly commissioned and qualified, this section is referring to both the rangers and the park superintendents. I left out some of it. As you know, they have all the police powers for what? Necessary to enforce all state laws and all rules and regulations made and published by the Tennessee Department of Conservation. All state laws, whole code, and all rules and regulations made and published by the Tennessee Department of Conservation. Your responsibility is not to carry out to enforce the regulations of the Department of Transportation or Human Services or some other. Although apart from this statute, I think you have some do have some authority, but we'll talk about that later. Going on, and to carry out properly and perform their duties within any of the parks, forest preserves, and recreational areas owned, leased, or operated by the state. Now that phraseology, within any of the parks and so forth, it tells me that your authority as a ranger under that sentence is within the parks, forests, recreational areas designated as one of those categories, and raises questions as to whether or what authority you may have outside the boundaries of a park. We have not, I have thought and have talked with some folks about asking the Attorney General for an official interpretation of that statute. But it seems to me that that portion of it, when it says within the parks, it means within the parks. What did he say? Outside. Yeah. All right. I think the same, but I don't think you get that authority from this statute as a private citizen, right? And that, right. And the difference, of course, between you're doing it, if I see somebody committing an offense, I've got every legal right to arrest them, although I have no police commission or police authority. You, and especially if you're in uniform, and if you're not, if you're known as a commissioned law enforcement officer, are perhaps feel more of a sense of obligation to make an arrest anywhere in the state, if certainly if a serious a violation was of any law was happening. I think it's a hard question as to whether we may want to get this statute changed to enlarge your authority, because what I see as a problem if my interpretation, and I think Richard's is right, if you act outside the parks simply as private citizens, I don't think the issue has been presented in the past, but it I personally don't think that that you would be acting as a state employee and be entitled to benefits as a state employee in the event you were injured, wounded, had something happen to you off the premises. And yet,
but with the uniform, if you had a uniform on, and you were off the guard, you would be perceived as a officer
yeah,
of the state.
that's right. Right. Now, yeah, you do, and the question though is, even though you're perceived as that, would you be when it came down to a hearing? All right. Let's look at what the second paragraph of this statute says. And I've got serious doubts about it. They will manage state parks and supervise their operations, enforce laws, rules, and regulations, and maintain order for the protection of state property and public welfare. Now, if you read that sentence just all by itself, that would seem to me to say you maintain order throughout the whole state for the public welfare. But looking at it in the context of this statute, I doubt that it would be interpreted that broadly. And then follows the section, the authorization to carry firearms or other arms while on duty as such park superintendents or park rangers. That's the guts of your authority as law enforcement officers. Yeah.
What do we decide? If we're off the park in uniform and friends, and we do something about it, and we get sued, does the state take care of it? That's the question.
And that issue is probably not going to be decided until it arises. And all we can do is speculate. The claim goes to the Board of Claims. Yeah. All right. Okay. He's so. I get you next. I don't know your name. Yeah.
If you make an arrest as a private citizen,
Yeah.
you don't have the right of restraint.
Oh boy. Okay. Yeah. But arrest is taking a person in custody. And I don't know how you can avoid, it seems to me you'd have to hold somebody. You have to be able to hold somebody if you're able to arrest him. We're really getting outside the area of my knowledge. But what was the second part of your question? I know that was going to lead to something.
Okay, if I'm in uniform
Yeah.
and something
Yeah.
transpires
Yeah.
and goes down,
And I have to, will the courts look as if I act as a private citizen, or as if I'm acting as a commissioned officer?
Right, and I honestly don't know, but I think that if I arrest somebody, surely I've got, as Bill said, got to try to take them to a local law enforcement officer as soon as, expeditiously as possible, or something like that. What difference? I don't see that makes a difference as to whether I'm a ranger in uniform or Joe Dokes walking down the street. Well, yes. Okay. All right. Then the question is: do you have what's your obligation once you take somebody off premises, so to speak? Should you take him to some other? Should you take him to the local sheriff or what? What would you do if you were not on the park? If you were somewhere else, it seems to me that you would take him to the local sheriff, jail, and so you're doing what ought to be done. Yeah, guy that I don't know. What's your name? Yeah. Hi. Yeah. Hi, Gary.
I think you left us a little bit confused. You said it would take a test case more than anything to find out who was covered by the Board of Claims in the event we had such a situation.
Yeah.
Or say we had to kill someone in a serious health.
Well.
The question I've got, you left us very vulnerable and
Yeah.
probably afraid
No.
to act if we did run on a situation. Cannot this be, the process be started to find out without private
Within limits, the Attorney General renders advisory opinions. Those opinions are not binding on the courts. And I don't think that an advisory opinion on a hypothetical case would be binding on the Board of Claims. And I mentioned the Board of Claims in thinking in terms, suppose somebody is injured and they want, they're entitled to workers' compensation benefits for their injuries as a state employee. I think you are left in a position of uncertainty. I don't accept the responsibility for it. I think it's an uncertainty in the law, and one that I'm good. If it bothers you, I'm glad to see that it does, because as I have looked at it for this, it has bothered me.
But the real question I'm asking, is there not any way we can find out now before that?
No.
That the law be changed?
Possibly. Yeah, the legislature changes the law, and it is possible to try to get something. Then the question may be, do you want to be given law enforcement responsibilities and wherever you are, and be treated as being on duty to the same extent that say that a police, any other police officer is within the scope of his territory. That is under the present law. Yeah.
I understand we're not under the same applicability here as a Tennessee Highway Patrol. But
Yeah.
they are commissioned officers.
Yeah.
They're assigned to certain areas. But if they're outside that area, do they have responsibility?
No, that's an administrative assignment, and they get moved around. But yeah, we do. But we get moved from park to park and area to area. You see, in other words, our department. See, you're part of the Department of Conservation and the Division of Parks. And we don't have statewide authority. We don't tell people what to do all over the state. We tell people what to do when they're in our parks. We're not in all. Let's pass on from that. I've noted, and you all note, that that's a problem that needs some attention.
Somewhere though in the state of Tennessee, it doesn't necessarily have to be a park, but you take the county sheriff's deputy or something, somewhere along the line, surely in past history, this happened where that deputy's been out of the county, but that's out of this jurisdiction, that park up being out of the park. If he was rendered a citizen or something, it's gotta be occasional.
If they don't hold the county commission, they don't hold the state commission.
Well, you only hold a park commission.
State commission.
Yeah.
They only authorize.
They come up, when I was in the academy, we talked about these deputies, and I said, I carry my pistol everywhere I go, you know, and pointed out that their jurisdiction was in their county. And they come up with this code, and said, well, of course, the code wouldn't carry anywhere to go. I think they have permission from your county sheriff to carry that weapon off with you, you have to have it from bill for us. So if he's out of his jurisdiction, it doesn't. So it's got to happen somewhere along the line, even if he's taking police officers into Arkansas, and he's pursuing some arrest down there, it's got to happen somewhere.
I'll look into it, and I'll be in touch with Don and Bill.
Let me ask one question, in the remote area, when I work at,
Yeah.
I help out Tennessee Wildlife Resource Agency.
Yeah.
Occasionally off the parks, and then I'm out
Right.
of the parks.
Yeah.
I'm still protected when you, they back me up on that.
We have to get help ourselves.
That, yeah. It seems to me that somewhere similar to so-called rules of hot pursuit and things like that, there's bound to be some authorization to, to act outside our strict park boundaries.
This would necessarily be a hot pursuit.
Yeah, I know it.
The sheriff's office come and say,
Says, come,
needs assistance.
yeah, yeah, right. Again, I've no problem as to your authority. What concerns me is whether you're really acting in your capacity as a park ranger. Let me ask you, do you get comp time for it? No? But you call, right. I expect this may be an area that needs some study beyond just ourselves.
I can imagine it was
Um,
for sure for the game big. That's the
You'd-
only help I have.
Yeah, yeah,
We sure would appreciate you to put it on the list of priorities.
okay, okay. I said if in doubt, prosecute for violation of a statute and a regulation when both cover. Most of you have probably run into that situation already. It's a lot easier. Wherever you go, there's a copy of the Tennessee Code, and anybody is familiar with that. But trying to deal with this state compilation of the rules and regulations is a real pain. nobody knows, nobody who doesn't work in it all the time really knows what it is or where it is. Most copies are probably not kept up to date, and if you've got to cite somebody for a violation, your job is probably going to be much tougher if you charge them with a violation of one of our park regulations than with a violation of the code. That's not to say don't charge them with a violation of a reg when it applies, but if something is obviously a violation of both, whether it's a traffic violation in the park, my suggestion is use the applicable law. But what do you do, and what's the basis for establishing punishment for violation of our parks regulations? I've been asked this before, and I set out in page 3 just a few of the steps in the reasoning process. Begin with the Commissioner's authority to promulgate regulations, which I've already mentioned. Second, any violation of a parks regulation is a misdemeanor and is punishable under the general laws relating to misdemeanors. That is provided by Tennessee Code Section 11-1-109 and by our Rule 0400-2-1-04. So, somebody says, you arrest somebody, charge them with violating the park regulations, say, look, that's just one of your regulations. That's not illegal. That's just one of your rules. Well, that's simply not so. A violation of a duly promulgated regulation is a misdemeanor. Brings me back, just to digress a minute, to one of the reasons you've got to be careful in your enforcement of regulations. You're dealing with things that are criminal offenses. And the regulations need to be judged then by the strict standards applied to criminal offenses. They've got to be clear enough for an accused person to understand what the rule is that he's charged with violating. They're entitled to the rights of persons accused of criminal offenses when you charge somebody, by which I mean preferring criminal charges for violation of a misdemeanor. I'm not concerned here when you just tell somebody, look, that's against the regulations, you can't do that, please don't do it. That's fine, but when it gets to the point where you feel you've got to carry somebody in and make an arrest, a violation of a regulation is a misdemeanor. Now, what is the punishment? Well, the regulations do not specify the punishment. I didn't say so here, but there are a couple of exceptions. I think it's in the archaeology regulations, simply incorporate some of the statutes. And so those are incorporated into the regulations. But when the performance of an act is prohibited by a statute and no penalty is imposed, doing the act is a misdemeanor. Got two kind of overlapping things. All right. The performance of an act is prohibited by statute. The violation of a regulation is doing something that the statutes prohibit. And so again, it's a misdemeanor. And then the punishment for misdemeanors, if not otherwise prescribed, is confinement in the workhouse not to exceed 1 year, or fine not to exceed $1,000, or both. Set those things out because I think that where the courts and perhaps even district attorney generals are not familiar with prosecuting for violation of regulations, the question may come up. If you have accused somebody of violating a regulation, you look at the regulation and it doesn't give any guidance as to what the punishment is. Well, you've got to go back through this process of back and forth from the regulation to the statute to find out what the court's authority is to punish somebody for violating a regulation. Anybody got any questions on it? Has that ever been a problem with any of you? Yeah, yeah. Well, it makes sense. They're a problem to me. Yeah. Oh, by OSHA? Uh-oh, okay, gotta watch my language again. All right. Proof of a regulation. If that evil day ever comes when you really have to prove what the regulation is, which is to say you've got a guy in General Sessions Court and you've got to establish what he's violated. The Administrative Procedure Act says that the text of a rule or regulation, same thing, in the Administrative Code or the Tennessee Administrative Register, the copy of the Certificate of the Secretary of State is evidence of what the regulation is, and it is to be accepted in all courts. This is a sample copy of the Tennessee Administrative Register, which comes out every month, and in which the various new regulations are published and certified by the Secretary of State. The statute refers to the Administrative Code, and I'll be darned if I can find anything, find any administrative code. Honestly, I think that this is a 1982 statute, and I think that it is contemplating a compilation to be designated as the Administrative Code. But the present administrative regulations are contained in big green loose-leaf notebooks about this thick and about 12 of them. Our regulations are in there. There are, or should be, copies of our regulations duly signed in the Office of the Conservation Department with all of the certifications on them that they've been properly promulgated. And if you need to establish a regulation, you or the local District Attorney General, and if the District Attorney General does not have the official compilation of the regulations, the thing to do is to yell for help and get one of us in the home office to either get it to you in the booklet, which would be impossible as far as parks regulations are concerned, because all our regulations were adopted before that little blue set of pamphlets came out. We would then get a copy of the applicable rule and have it duly certified, which I think could be done either by the Secretary of State or by the Commissioner. And under the Tennessee Rules of Civil Procedure, it could be introduced in evidence as evidence of the regulation. Additionally, as indicated in the top of page 4, the courts can take judicial notice of state regulations, and that means they don't have to actually be introduced in evidence. But as long as you furnish a copy of the regulation to the court in a form that satisfies the court that that really is the current regulation, not one that's been superseded or repealed 5 years ago, the court can simply take notice of it just as the court looks at the statute, the Tennessee Code, and judges by reading the code what the law is. There again, have you had trouble ever establishing what a regulation is in a general session? Because I prepared this without talking to anybody about the practicalities of it on that point. It just seems to me that bound to be problems come up. but I don't know. Show of hands. How many have had trouble? Yeah, all right, 2, 3 admit it. 3 honest people in the class. All right, what are the rest of your, when you've got to bring somebody in, let me ask you this. How many, is this whole thing a futile exercise? How many of you have ever had to charge somebody in court with violating a regulation? Okay, all right, so practically all of you have used the regs in a court enforcement sometime or another. What actually happens when you get to court? Anything, or do they go off on a plea of guilty, a bargain, or what? Have you ever had to come in and show the General Sessions judge, this is what the regulation says, and that's why he's guilty of the violation? Yeah. You carry, okay, all right, you carry them the little green book, all right, and they accept that? Oh, got it made. All right.
The book doesn't give fines, so it doesn't give.
No, it doesn't. And that's why I went into a little detail in my outline. If you want to keep that with you, I think that you can educate both the District Attorney General and the judge. So, yeah. Yeah. And yeah, I think the only the only problem would come up if well they wouldn't set it higher than the law permitted, because as long as they know it's a misdemeanor and they've got general misdemeanor authority to set the punishment, we're okay. I can visualize that sometimes somebody look at the little green booklet and say, look, that's not official, and it's not official. But if it satisfies the judge, it's probably going to be enough. But if you've got to go beyond that, then you may need to get a continuance and get us to get you a properly certified copy of the regulation itself, and we can do that and get it out to you. All right, not going to talk about many of the specifics, but on page 6, what I began with is going through the chapters of the regulations in order, and for some of them, a section-by-section listing with very little more of the various rules, and with a few additional comments. Public use and recreation, we left out the chapter designation. Incidentally, your little green book does not have exactly the same numbering system that the regulations have. It's sort of a shorthand excerpt from the numbering system. And public use and recreation is chapter 0400-2-2. If you ever needed, if somebody says, where is that in the official rules and regulations of the state, that's it. The hardest thing in the world to find a regulation in the official compilation. It's 12 volumes without an index or even a table of contents. Just got to know somehow where each department's regulations are. All right, what does this chapter on public use and recreation say? It seems to me that this is the section or the chapter of the regulations that is one of the most, one of those that you would use the most. On the .01, abandoned property shall be impounded. That's the authority. If something's left unattended for 24 hours, it can be impounded. But what then? I'll be darned to find out. What do you do with it? If you pick something up, you're stuck with it for the time being. And on attachment of property, I'm trying to think what You got a new one on me. I can't think what you're referring to. What is it? Before, really? Look up. Okay, I would say if that applies to motor vehicle impoundments statewide, that certainly would restrict you on the motor vehicles. Other things, if other things are just left, more or less abandoned on the park, whether it's clothing or boats or equipment, our 24 rule may still apply. Once you take possession of something, you do have certain obligations to safeguard it. And I think this is one of the deficiencies in our law, is that it does not provide an easy way for us to get rid of that property. We've had a fit worrying about what to do with boats abandoned in the marinas. And after a good deal of effort, we've got a new marina lease now, under which the owner of the boat contracts with us and agrees that we can take some steps to dispose of the boat if we have to pick it up for non-payment, or if it's just abandoned. But abandoned property is a real headache in the law. It's a headache with landlords and tenants. If a tenant abandons a house or an apartment, leaving furniture in there, there was no easy answer to that until the State Landlord and Tenant Act was adopted about 5 years ago. And we're in much the same problem where people just abandon property on some other state facility. But we can sue the owner and for any violation that may have taken place, including abandoning the property, get a judgment and sell the property. As far as inns are concerned, we've got an innkeeper's lien, which is an easy way of disposing of things left in the inn. I think we do have an obligation to maintain the property for some uncertain time, to give people a chance to come claim it. Don, you got some help on that?
No, I just had a question, Lee. With any property being distributed, say there's lost property,
As-
somebody loses that wife and it's on the ground.
Yeah.
Why do you
Well, it seems to imply something a little different to me. But as a practical matter, how in the world do you tell whether it's lost or abandoned? I mean, if somebody leaves a cabin, they leave a suitcase. Well, did they just forget the suitcase when they were moving out? Or did they just... If you'll get a call back.
When you find a boat or something, you have a serial number and usually it's like it will watch.
Yeah, you really can't. Yeah.
My point is that we just have a lot of problems with regulations concerning metal detectors.
Concerning what?
Metal detectors, use of metal detectors.
Yeah,
And what they're looking for is usually old rings and so forth.
that have, yeah,
What people look for us to keep them from just establishing the law.
yeah, yeah.
We may have put another
Well, yeah, we may need to.
Right there in that very area on page 7, you get there, metal detectors.
Yeah. Can I?
The way I read it, it says they're prohibited in natural and historical areas,
Yeah,
but they're not in recreational areas.
yeah,
Our park is designated as recreational area park.
right. Okay, let me come to that in just a sec. Most, okay, on page 6, I don't know whether you have any trouble with noise, but under those rules, .03 on audio devices does provide language to restrict noise that would unreasonably annoy persons, and people are supposed to have a permit to use a PA system for any purpose. The various restrictions against begging and soliciting and hitchhiking. Question had come up earlier about solicitation, the anti-solicitation rule that the General Services and Personnel Departments have promulgated, and I referred to that there in the middle of page 6. I had a question during the break about disorderly conduct. Our Rule .07 prohibits disorderly conduct and gives what I think is a pretty good definition, but part of what is defined as disorderly conduct involves, I've forgotten exactly the wording, but something like abusive speech. And that type of statute has run into trouble in the courts as being too vague to satisfy due process of law. And so I have simply raised the question here, and I raise it, and I'm not going to try to answer. There is certainly a possibility that disorderly conduct based on mere language would not stand up on challenge based on other cases. But disorderly conduct by fighting and boisterous conduct and so on is in there as a part of our regulations. All right, obviously intoxication, drug incapacitation, going over to page 7, number 16, that is prohibited, but I notice that the standard our regulation uses is that it's prohibited if it's to a degree that may endanger life or property or unreasonably annoy persons in the vicinity. That's not the greatest standard in the world, and that's something that if we think about some amendments to the regulations, we might get that to where it can come closer to prevailing, you know, like a .10 or something. That standard bothers me some. Huh? You know, that's another good point. Why duplicate by regulation things that are adequately covered by statute? That's, yeah, well, we'll undoubtedly be thinking about that. Yeah.
So someone I've done that just a little bit.
Yeah.
Someone will curse in very loud, listed language or whatever. You don't necessarily have to get them for, you could cite them for disturbing the peace in that situation, couldn't you? It'd be no different than a loudspeaker or anything else.
Well,
They don't mean what it is.
I don't see any fundamental reason not to accept that the plain truth is, if you've got a good PA system, you really can make more noise than you can with just with the natural lungs. I would say use the disorderly conduct regulation and leave it to the accused to challenge it. If you need to get somebody on something and there's just no other way to deal with boisterous and extremely offensive conduct, even though they are not physically getting into something, this is what you'd better use. If it's as bad as you're suggesting, it's going to end up in some physical violence before too long, because somebody's not going to put up with it. Alcoholic beverages. All right, I'm not an expert in this area, and as I think you can already tell, criminal law is not my element, and that's why I am here to talk about regulations, but not criminal law and procedure. But Our regulation says consumption of alcoholic beverages within state park areas which are open to the general public is forbidden. All right. That's all we say in our regs about alcohol, other than the intoxication. Now that's it. I have commented consumption implies possession. If you can consume, if it's okay to consume it, it's obviously got to be okay to possess alcoholic beverages. But the problem is that possession is not forbidden. The rule does not prohibit consumption except in areas open to the general public. Now, what areas are open to the general public and what areas are not open to the general public? Well, we have not tried to answer that sticky little question in the regulations. What I've put here is simply, my thoughts on it. Presumably cabins and rooms that are rented or reserved to the use of specific guests are areas that are not, during that time, open to the public. Here again, I don't know what your experience has been in this area, but I've got somebody with a comment. Is he in a... Well, where's the... Open to the public has got to imply something about, the park area. I don't think you can just pull a bag over your head and stand in the middle of an inn lobby and and say you're not drinking in public in an area open to the public. But yes, it does. And I'm not so wise as to know where the line is between public and non-public. Okay, and that's another possible interpretation. The whole park is open to the public, but at any given time, some areas of the park are not open to the general public because we reserve them and rent them to specific people and specific groups. Yeah. Yeah. Yeah, and right, and that gets down to the practicalities of it. You've got no business breaking into somebody's motel room without probable cause anyway, and it's in the privacy. Beyond the cabin and the inn room, I feel we get into a gray area. And that's why I've limited my own opinion. Yeah.
Many of you referred to the old Green Book. Commissioner Allison had this rule changed. He went through the whole process, and the rule actually reads as Lee has it on your paper. It's consumption, not possession, which is against the regulation.
I see.
Public areas is indeed those that are open to the public that we have not leased, have not rented. That's a common rule that people don't know has been changed in this book. How many of you are aware of that? Well, that's what got us confused, Bill.
Yeah, well, that's understandable. Okay, now then, all right, I'm not, each of you, most of you, you're from many different counties. You've got, to some extent, different rules. But remember, as I've, state law and county municipal restrictions on sale and possession still apply. If your park is in one county, our having adopted a regulation does not change the general laws of the state or the county ordinances. And the fact that we say possession of, in effect, if possession is not a violation of our regulation if it's in a cabin room out of public. That's got nothing to do with enforcement of the general laws of the state dealing with the possession and the sale of alcoholic beverages, whether it be 5% or under or any other intoxicating beverage. Huh? About
To me, public would be, each time would be visible to anyone. I don't care if you know, if it's a camping area, wherever he might be, the public is anybody. I mean, I may be the rainbow.
yeah. Well, this is one of those tough issues that our regulation does not answer, and I think you need to expect here as in other areas, they're going to be, you're going to get away, people are going to get away with things in one county and one court that they don't get away with in another county and another court. This is a vague regulation. That's the best I can say. But I don't have any serious doubts about the fact that that what our statute applies to is the consumption in public areas, which, you know, again, what does that tell me? That tells me that you can. You know, there'd be no way of consuming an alcoholic beverage in an inn room without transporting it from the from a inn gate to the inn and going through, you know, possessing it in some public areas. It would be stupid to have a rule that said, in effect, you can consume alcohol in private, and then to make it illegal to possess it in any public area, because you simply can't get to a private area without going through a public area when you're dealing with a state park. And that may be why the regulation was amended to apply to consumption. Anyway, so I have no problem with that, and no problem with the fact that even though something may be permitted by our regulation, if it is a violation of the state or local alcoholic beverage laws under local option and so on, it's still a violation. Pardon? Do I what? I'm sorry, I didn't hear you.
If you had a county that was referred to as being dry, I mean, we don't have any of that kind.
Yeah, yeah. Yeah, well, you know, there are quantity limitations and
What is there, as to how much beer you can have, is there a quantity to that?
there is on whiskey. I tell you, I don't know what the specifics are. I'm tried to dig into that.
Like they,
Um,
last summer down on the park, there was people pulled in and unloaded 22 cases of beer.
Yeah.
They were setting up to have a party.
Yeah. Yeah, guy in the back. That's not my problem. That's a flippant answer, and I'm trying to avoid a difficult question. But in all honesty, I think that many of our park signs are inaccurate and misleading, where they I can't remember one from another, but I know I've seen signs that say something to the effect that possession of alcoholic beverages is prohibited, or something to that effect.
Incorrect.
In my opinion, that's incorrect.
Superintendent, make a graduation by
I think not in an area, you see, not where it's specifically covered by a regulation. That's just like a regulation can't contradict the statutes. You and your superintendent cannot do something that contradicts a regulation. You got to find your authority for anything in some kind of statutory or regulation authority.
Sir.
Yeah.
Mr. Conway, did you know in some parts, the possession and the consumption of beer is just a cover-up for the field droppers and the pot smoking? They throw it away, and so you want to smoke the pot, drop the field. So you think you've done your job and you were throwing away the beer. And it's just a cover-up.
Yeah. Nobody said it was easy.
You need a sign up as a gift.
Yeah, Bob. Yep.
On the consumption of alcohol, past both of them, the consumption of alcohol, say, the good old boys bass fishing clubs rent picnic shelters.
Oh, Lordy.
Church tried to rent
Oh, yeah. And there you got nice open.
public view, but private. How long is that? The other question is,
Yep.
you give citation, drinking alcohol, give the citation, how much of this alcohol do you take to that? Do you take that one glass, one
Yeah.
take the whole case, exactly?
Yeah.
That he's obviously
Take. You obviously don't need to take all of it to establish unlawful consumption. What you're, I don't know how much you ought to take. You could deal with that on contraband and evidence. I tell you, there is no answer for the picnic shelter problem. That gets back to your point. If it's in public view, you take the attitude that it's in public. And I think that there's a lot to be said for that. In the eyes of, yeah, you've got a little area. You're much better off if you're within 4 solid walls. I say you, I mean the drinker is it's a vague provision. There was a mention about the metal detectors, and I mentioned that at the bottom of page 7. Here again, what the regulation says is that the use of metal detectors is prohibited in natural and historical areas except for boat and aircraft navigation, but not in recreational areas. That is a real problem. I know it is in some places, and I've got some cross references on page 8 on that. But as far as our regulation is concerned, the prohibition applies to the natural and historical areas. All these other sections, you can scan down them sometime. There's just a whole lot of restrictions on everything from sanitation, traveling on the trails, hunting and trapping, and it's all set out in the regulations. Roman 6 has to do with the marinas, which have very little regulations. Roman 7, beginning on page 10, is your vehicle and traffic safety. I made the very briefest reference to those sections. They are almost entirely the standard state laws, although there are a few extra things like restriction of vehicles to areas that are designated on the parks. Provisions on the use of motorcycles and motor-driven cycles, where and under what circumstances, trail bikes, mini bikes, ORVs. There are, throughout this whole chapter of the regulations and the preceding one, there are a good many areas where the superintendent is given the authority to make regulations in addition to make rules, to make, operating conditions in addition to what the regulations set forth. And in almost every case they say, and to post that rule. If it's a speed restriction, you post it out in the road or the trail. If it's a restriction on what part of the park you can build fires in or camp in or do something else in, it's supposed to be set out on a map, and the map should be kept available in the park office so people can find out where the restrictions apply and where they don't apply. And I assume that sort of thing is done. Yeah, the guy by the window.
Okay, what happens is like making an arrest, and you transport the individual into the local sheriff's department, official there. Say if there's an accident on the way in. What kind of legality is going to be found in?
An act done on the way, you mean?
Like we have an accident going in,
Yeah.
Iraq, some
Okay. Yeah. Okay. Right. Well, that gets us back to what we spent a good deal of time on earlier, but it's a little different aspect of it. It seems obvious to me that if you are transporting somebody to court or going to court or going to jail, you're in the course of your duties as a ranger. My concerns about the statute that we were looking at before is as to your general, the extent to which you are acting in the course of and scope of your conduct as a state employee. If you get into law enforcement just while you're walking down the street in town. I don't have any problems where you are, where you are directly in the conduct of your duties as a ranger and a department employee. Let's.
Y'all gotta eat.
Okay.
A couple of quick comments. One, first of all, thank you, Lee. We're sorry to put you on the spot as far as for the legal questions that's supposed to be today.
That's what I want.
But we did make some notes, at least I did in the back, but hopefully you did too. The main question about this idea of liability and who's going to protect you and what type of workers' comp can you expect. At least we can get an opinion. It might be the same that we've heard for 30 years, that they can't make a decision until. but somewhere, like somebody said over here, it had to happen sometime. I also want to make a comment, I just drafted a memo, and we will be soliciting comments as to which portion of the rules and regulations that you've had problem administering, that you find ambiguous, or difficult to interpret, and we're going to be revising these. The whole state is having to revise all the rules and regulations. We're going to try to get a little bit ahead. Lee's going to comment from a legal standpoint, Bill from a law enforcement standpoint. We'll hope you'll comment, and what I'm going to do is ask the President of the Rangers Association to nominate 3 people to act as filters to get the comments to me by a certain date. We need your help because, again, the metal detector question, the alcoholic consumption question, all those things which are being interpreted differently across the board need to be addressed, and try to write them in a way that they're not ambiguous and that they are clearly interpreted in a manner that you can enforce them. That's very difficult, folks. That's extremely difficult. So you're better off when you do a lot less of this and it's opposed to a lot more writing. But do know we are reconsidering many of these questions that you brought up today, and we've had questions about them since I've been in. And I hope that we can have a better set of rules and regulations, a little bit clearer, a little bit more clear cut at the end of this year, calendar year. Hopefully the January will be something we can shoot for. We'll present those through the process that Lee talked about, and hopefully they'll be promulgated, and you'll have a better set. Bill, is there any other things you need to tell now? Lee, again, thanks.
Tomorrow morning, our first class will be in the gym at 8 o'clock. Gym shoot. In regards to these regulations, this is how these regulations came about the first time. We were operating with 10 rules for the whole
Many
division.
state parks still do that.
These regulations were suggested by these men in their capacity 10 years ago.
And it's time to revise. It's 10 years old. It's past time to revise. So we're going to push your help again. Do you have a question?
Point out some of the signs that can help you to recognize drug abusers. Literally thousands of different drugs are a part of today's drug scene. Many of them are a valuable part of the physician's arsenal against disease. Others have no legitimate medical use. All of them can cause problems when they are abused. Most of the many drugs that cause trouble for the authorities fall into 6 families. These include narcotics, depressants, stimulants, cannabis derivatives, hallucinogens, and inhalants. Let's look at the narcotics first. Technically, the term narcotic is applied to those drugs that are derived from the sap of the opium poppy and their synthetic equivalents. Heroin is by far the best known narcotic. It is also probably the most troublesome drug ever developed. In addition to heroin, a number of other narcotics are also commonly abused. These include morphine, a widely abused painkiller, methadone, a drug that is used to help heroin addicts control their drug craving, and codeine, a popular cough suppressant and painkiller. Heroin is what is termed a natural narcotic. It is manufactured by chemically treating opium, the congealed sap of the opium poppy. At the present time, the heroin used in this country is made from poppies grown in 3 areas: Southeast Asia, Mexico, and Turkey. Well-organized groups of international criminals make enormous profits by smuggling heroin into this country. This particular shipment was found concealed in a shipment of canned tuna fish. By the time heroin reaches the addict, it has been diluted over and over again with various adulterants, such as milk sugar and quinine. As a result, the drug is rarely more than 2 to 6% pure when it is sold on the street. Heroin is usually sold in the form of a crystalline powder. Its color varies from white to dark brown. It may smell like vinegar because acetic acid is used during the manufacturing process. Heroin is frequently offered for sale in capsules, balloons, glassine envelopes, or wrapped in paper or tinfoil. Heroin can be inhaled or smoked. However, most abusers in this country prefer to inject it into their veins. When used in this manner, the drug has the maximum effect. Before heroin can be injected, it has to be dissolved in water. This is done by heating it in some kind of cooker. such as an old spoon or metal wine bottle cap. As with all drugs, the effects of heroin vary from user to user. Ordinarily, an injection of heroin induces a brief period of intense stimulation immediately after the drug is injected. This is known as a rush or a flash. The rush is normally followed by a period during which the user experiences relaxed drowsiness and a sense of blissful well-being. Known as the nods, this state of euphoria can last from 1 to as long as 6 hours, depending on the size and purity of the dose and experience of the user. As doses are repeated, the user's body becomes accustomed to the drug and develops a tolerance for it. The result is that as time goes by, larger and larger doses are needed to produce the desired effect. Once such a tolerance develops, the user's body needs the drug to function properly. If supplies are cut off, the user suffers withdrawal symptoms. These may include nausea, cold sweats, cramps, and diarrhea. Users who have reached this state are said to be physically dependent to the drug. In addition, people who use drugs regularly often develop an emotional need for the mental effects they produce. They are then said to be psychologically dependent upon them. In addition to the narcotics, there are a number of other commonly abused drugs which depress the nervous system. They are often grouped together under the name of depressants. The most commonly abused depressants are barbiturates, such as phenobarbital and secobarbital, and tranquilizers, such as meprobamate and diazepam. Barbiturates and tranquilizers are found in a wide variety of tablets and brightly colored capsules. Some of the most common street names for these are barbs, libs, goofballs, and yellow jackets. Depressants are usually taken orally, although hardcore abusers may inject them. They are frequently used as a substitute for and taken along with other drugs, such as heroin. The effects of barbiturates and tranquilizers may wear off in an hour, or they may last for several hours. The difference will depend on both the type of drug and the size of the dose. Abusers quickly develop both physical and psychological dependence on these drugs. Overdoses can cause death. Withdrawal from many depressants is dangerous. Unless it is conducted under medical supervision, the results can be fatal. Many people combine barbiturates and tranquilizers with alcohol. This is an extremely dangerous form of drug abuse. The effects of the combination are far more powerful than when either one is taken alone. Fatal overdoses are not uncommon. Illicit supplies of depressants are obtained in a number of ways. Hijacking and theft from warehouses and pharmacies are fairly common. Careless or unscrupulous physicians overprescribe these drugs. Supplies are also smuggled into this country from abroad. So far, we've considered drugs that depress the nervous system. A number of other widely abused drugs have exactly the opposite effect. They provide intense stimulation. Two of the most common stimulants on today's drug scene are cocaine and the amphetamines. Cocaine, or as it is often called on the street, coke, snow, or flake, is usually found in the form of a fluffy, white, crystalline powder. It's extracted from leaves of the coca bush, a plant native to the Andes region of South America. Most users inhale, or as it is called on the street, snort cocaine, though a small number of hardcore abusers prefer to inject it intravenously. As is the case with all drugs, when cocaine is injected, its effects are much more severe. Cocaine produces intense stimulation within moments after it is taken. Users become excited, nervous, and talkative. They often experience a feeling of total elation, as though they were on top of the world. This euphoria is short-lived, lasting for only a quarter of an hour or so. It then gives way to fatigue and listlessness. The amphetamines are a large family of synthetic stimulants. Their effects are similar to those of cocaine with one important exception. They can last for hours rather than minutes. The powerful stimulation that amphetamines produce has led to their widespread abuse. Truck drivers use them to avoid going to sleep on long hauls. Housewives and executives take them to get through the day. And students rely on amphetamines to keep awake before an important test. Users can quickly develop strong psychological dependence on such stimulants as cocaine and the amphetamines. However, at the present time, researchers have not established whether or not the abuse of these drugs produces a true physical dependence. During the last few years, the use of such drugs as marijuana, hashish, and hashish oil has become increasingly common, especially among young people. All of these drugs are derived in one way or another from the hemp plant Cannabis sativa. Marijuana is by far the most commonly used drug in this family. It is made from the dried leaves, flowering tops, and small stems of the cannabis plant. The active ingredients are a group of complex chemicals known as tetrahydrocannabinols, or THC for short. Hashish is another drug produced from the cannabis plant. It is made by compressing the THC-rich rosin exuded by the plant into slabs or cakes. Hashish oil is another cannabis product, and one that has become increasingly popular. It is made by treating marijuana in much the same way that coffee is prepared in a percolator. The drug that results is a dark, thick, oily liquid that is many times more powerful than either marijuana or hashish. Marijuana, hashish, and hashish oil are usually smoked. They can, however, also be eaten, and sometimes their users will include them in such snacks as cookies and brownies. The paraphernalia shown here is representative of some of the literally thousands of devices which are now sold on the open market for the convenience of marijuana smokers. The manner in which these drugs affect the nervous system is not fully understood. Small doses provide a mild form of intoxication known on the street as buzz or high. Larger doses can cause disoriented behavior. In cases of extreme abuse, some users can suffer from psychosis and paranoia. A great many natural synthetic and semi-synthetic drugs can cause bizarre changes in the manner in which their users perceive their surroundings. This family is referred to as hallucinogens or psychedelics. Many of the hallucinogens that are popular in today's drug scene are or were originally derived from plants. Mescaline is a good example. It comes from this small cactus, native to Mexico and the American Southwest, known as peyote. Other hallucinogens, such as LSD and PCP, are produced in clandestine laboratories, such as the one shown. A word of caution is due at this point. If you ever find one of these labs, look out. Many of the processes used in them employ extremely explosive chemicals. A single false move on your part may cause a whole place to go through the roof, literally. The only safe way to handle such situations is to call for the assistance of a trained chemist who can show you how to safely deactivate the lab. The odorless, tasteless liquid shown here is perhaps the best known of the hallucinogens. Its scientific name is lysergic acid diethylamide. On the street, it's called LSD, or acid. LSD is an extraordinarily strong drug. The amount you see here can be diluted to provide literally thousands of doses. LSD is sold on the street in many forms. It may be in pills or tablets. It may be also dabbed on such things as sugar cubes or small squares of gelatin or blotting paper. LSD is taken orally. It can have a wide range of strange and unpredictable effects. Users experience profound changes in the way they perceive the world around them. Stationary objects may seem to move, colors may intensify, and sounds may take on entirely new qualities. Some users experience spectacular hallucinations. These effects can last for as much as 6 to 8 hours after taking a dose, and they can recur weeks or even months after the last time the drug was used. LSD LSD and other hallucinogens can have a terrifying effect on some users. It is not uncommon for such individuals to be driven into an utter panic by them. Under the influence of hallucinogens, some users may commit totally irrational acts. There are all too many cases on record where persons under the influence of LSD were injured or killed because they thought that they could fly from trees or tall buildings. Still others have been known to dive out of high windows while in the grip of a drug-induced panic. Users do not develop a physical dependence upon hallucinogens. The degree to which they may develop a psychological dependence upon them is not known at this time. Another drug that is causing problems today is phencyclidine, or PCP, known by such other street names as killer weed and angel dust. In some doses, it can produce hallucinations and pronounced feelings of estrangement and depersonalization. PCP is often sprayed on parsley leaves or marijuana leaves and smoked. In a disturbing number of cases, it produces such adverse reactions as dizziness, vomiting, paranoia, and violent outbursts. The last family of drugs that we'll consider are the inhalants, or as they are sometimes called, the deliriants. This group includes such substances as gasoline and the volatile solvents found in glue, paint remover, nail polish, and similar products. The propellants found in aerosol spray cans may also be used as inhalants. Other examples are anesthetic gases, such as nitrous oxide and ether. With the exception of the anesthetic gases, which seem to appeal to a somewhat older crowd, most inhalant abusers are young adolescents. Perhaps the most common way that these drugs are abused is to put some in a plastic or paper bag. The youngster then holds the bag, as shown here, and inhales deeply. Inhalants have a depressing effect upon the central nervous system, and their abusers usually experience sensations similar to those caused by alcoholic intoxication. In some cases, inhalants produce mild hallucinations and bizarre and agitated behavior. Users may develop a definite psychological dependence upon inhalants. The extent to which a physical dependence develops is not fully understood. Inhalant abuse can be fatal. If the user loses consciousness, the bag may cut off the air supply and cause death by suffocation. Sniffers can also be killed if they experiment with such toxic products as oven cleaners and cleaning fluids. Only a complex series of laboratory tests can determine positively whether or not a person is using drugs. Nevertheless, there are a number of clues that can give you a strong reason to suspect that someone is a user. These clues fall into three classes. First, you may find either the paraphernalia associated with drug abuse or the drugs themselves. Second, abusers may show certain characteristic physical symptoms. And finally, many abusers exhibit a number of different kinds of drug-induced behavior. A wide range of paraphernalia is associated with many different types of drug abuse. Here, for example, are some of the many different devices that are commonly used to smoke marijuana and hashish. And this curious contraption is a special kind of pipe that is used to smoke hash oil. Drug abusers often inject themselves with heroin and a variety of depressants and stimulants. Here we see some of the injection paraphernalia that they use. The syringes are made from medicine droppers. The spoon is used as a cooker to dissolve the heroin before it is injected. And here we see a collection of some of the different kinds of paraphernalia associated with sniffing cocaine. In addition to the presence of paraphernalia, you should also be alert for the physical symptoms that are often associated with drug abuse. For example, many heavy drug abusers have a generally run-down physical appearance. This is partly due to the fact that they ignore their personal hygiene and nutritional needs. Most heroin addicts inject themselves intravenously. This is also the case with many of those who make heavy use of depressants and stimulants. Such abusers frequently develop tracks or needle marks and scars like those shown. Look for them along arms and in other places where veins are easy to reach. As most abusers use unsterile needles, they may develop sores and abscesses. Here we see a particularly severe case. Drugs may also affect the pupils of the user's eyes. Look for constricted or pinned pupils with narcotic or depressant abusers. Exactly the opposite is true with stimulant abusers. Such drugs as cocaine and amphetamine will often cause the pupils of the eyes to be abnormally large or dilated. The intense abuse of cocaine can damage the user's nose and cause sores such as these. In particularly severe cases, the cartilaginous wall between the nostrils can be pitted or even completely eaten away. A subject's behavior can also indicate that he or she is under the influence of drugs. People under the influence of heroin or a depressant, such as one of the barbiturates, often appear lethargic and in a state of stupor. Marijuana may affect users in much the same way. You can often distinguish such users from common drunks by the fact that they do not have an odor of alcohol on their breaths or on their clothes. By comparison, stimulant abusers frequently tend to be hyperactive. They're often nervous, talkative, and restless. Sometimes they indulge in meaningless behavior and repeat the same act for long periods at a time. Drugs such as LSD and similar hallucinogens can cause bizarre behavior. Users may imagine themselves as angels or birds and try to fly. They may also complain of experiencing vivid visual or auditory hallucinations. Occasionally, drug users go berserk and cause a serious threat to police officers or anyone else who happens to be near them. This sort of paranoid behavior is rare, but it can be extremely difficult to handle. It most often results from the heavy abuse of stimulants or barbiturates. For the last few minutes, we have looked at some of the many substances of abuse that are part of today's drug scene. We hope that you will find this information helpful in your work. We wish you the best of luck in all your cases. This program was prepared by Police Science Services for United Learning.